Coming up on This Week in Law, who better to break down the new DMCA exemptions than EFF's Corynne McSherry? Are Google and Verizon helping the cause of net neutrality or not? Is Twitter helping the cause of anonymous public lewdness or not? Ben Snitkoff and Evan Brown share their thoughts on all this and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, episode 73, Net Lewdtrality. Hello and welcome to This Week in Law. I'm Denise Howell, and we're here this week on Friday, the 13th of August, with Corynne McSherry of the EFF, which is a wonderful thing because we have lots and lots to talk about with her. Hello, Corynne.
Hi, how are you?
Great. Thank you so much for coming on the show. There's been so much going on that is on your radar. We can't wait to get into that with you. But first, I want to introduce our other guests. Ben Snitkoff from technicallylegal.org. Hi, Ben. Welcome back.
Hi, Denise.
Hello, hello. Thanks so much for joining us again. And also, of course, we've got Evan Brown from internetcases.com and the law firm of Hinshaw and Culbertson in Chicago, Illinois. Hi, Evan.
Hello. Hope your Friday the 13th is going safely so far.
Well, as I was saying off just before we went online here or on the air, my kitchen sink exploded this morning. So I'm blaming that entirely on the holiday.
Right. Yeah. And here in Chicago, we've got the air and water show going on. So if you hear, F-16s flying by my window, you'll know what that's all about. So it's nerve-wracking in any event, but especially on a Friday the 13th for stuff like that to be going on.
I thought it was just them filming Transformers 3 again.
That too. I've got that view out of my window once in a while, but I'm careful not to film it. Yes. I don't want to get in trouble.
All right.
You
good.
can film it, just don't share it.
Okay. I'll share it with you guys. You wouldn't tell.
No. Us in the chat room and just, a few good friends on live.twit.tv, which of course you can join us when we record the show, which is Fridays at 11 Pacific at live.twit.tv. And I always try and post up a few Facebook questions before the show. You can check those out and participate with us at facebook.com/thisweekinlaw. And what I want to get to first off here is kind of breaking news. Oracle has just decided to sue Google for patent infringement relating to Java. And I don't know that any of us have had too much time to look at this or think about it. But it's kind of interesting because of the nature of Java, or much of it, or species of it at any rate, as an open source kind of creature, something that is licensed under the GPL. So, Ben, have you looked at this at all? And can you tell us why we have a lawsuit going on over something that is supposed to be open source, and what the ramifications are if this goes forward and winds up being a big deal?
I'll do my best. It's a pretty complicated 12-page complaint. It involves a whole lot of patents. Essentially, the patents relate to base parts of Java. Specifically, a couple of them relate to security in Java. Some of them relate to one's called a method and apparatus for resolving data references in generic code, and it's about how code gets resolved in the process of being compiled and executed. And from what I understand, and I guess, Corynne, you can back me up on this one. The GPL, while it grants you a license for the code, which is covered by copyright, it doesn't necessarily also grant you a license for any of the patents that you would use while executing that code. Or in Java's case, in Google's case, what Google did was they used a different implementation of Java. Essentially, there's an open source virtual machine that would compile, that would run code that had been converted from Java. So essentially you could write Java code and then run it through this program that would convert it into something that Google's executables that Google could run on Android. And in the process of doing this, they may have violated, and Oracle certainly thinks that they violated some of the patents that...
there he is. Sorry, you cut out for just a second.
Okay, where was I?
You were talking about the open source virtual machine that is or is not part of Android.
Right. So Google implemented their own virtual machine that runs essentially Java code, which may or may not violate, rather infringe on some of Oracle's patents. And these were patents that originally Sun Microsystems obtained when they made Java, and then Oracle, when they bought out Sun, took those patents along with them.
Right. So Web2629 in the chat room is saying that, saying with 3 exclamation points, that GPL version 3 has patent clauses, which...
This was under GPL 2, though, I think, wasn't it?
There we go.
Yeah, the patents definitely go back to 2002, 2003, up to 2005. And obviously, Oracle and Sun could have licensed Java under whatever version of the GPL they wanted. They're not bound to choose the GPL 3.0.
And in fact, they did choose 2, I believe. That's what I read.
Mm-hmm. Mm-hmm. Right, because I remember there was a lot of controversy when 3 came along because it was trying to iron out some of the bumps in the road that had led to other litigation like this. So we now see those chickens coming home to roost. Mm-hmm. Corynne, any thoughts about this lawsuit?
Well, I have to confess that patent law is not really my bailiwick, so I don't have a lot to say about it. I do think it's interesting that it's Oracle and Google. I mean, I think that on the one hand, there's a lot of incentives here to just settle this thing quickly. And the only thing I think of that goes against that is
James
that
Gosling.
Google doesn't settle easily as a rule. Google has a history of standing up legally, and certainly in the copyright space. So I think it's going to be a little while before this one gets resolved informally. But I do think ultimately that's the most likely outcome.
Right. And it reminds me, just because it's something that has kind of been on our radar for a couple of weeks here that we haven't talked about on the show, but there's another GPL issue that I guess was quite, it's nowhere near the front page Financial Times kind of news that this lawsuit is. But there was quite a dust up a few weeks ago about WordPress and the thesis theme. And again, it was a question of the GPL and its scope and whether portions of WordPress were actually at issue and being reused in creating a theme for WordPress, and just basically what the scope of the GPL would be and when it would apply and when it would not. And there were some very vehement opinions on both sides about whether this was a licensed activity or not. And Jonathan Bailey, who was on the show with us last week, did a great post and roundup of all the pros and cons, et cetera, on that is in our show notes if folks want to check it out. He's at plagiarismtoday.com, or you can find the show notes at delicious.com/thisweekinlaw/73. But it just reminds me how the GPL in particular seems to be something that people are not afraid to try and poke holes in. Creative Commons has been around for a few years, and it has thus far held up in court, but is nowhere near as widespread as the GPL. It's kind of like the Apple Microsoft issue. Their market share is not quite what the GPL's is, so we probably see more legal issues springing up around the latter. But this is one to watch, and as you say, Corynne, I think it'll be interesting to see what Google does and how Google responds. There are lots of folks who think they really have to stick to their guns here and not sacrifice the GPL, that this should be something that Google takes a principled position on, as it has done in many other cases, instead of just a quick settlement or get out the door and do what we have to do to make sure Android runs. But we'll see. No way to know on that. One thing that we do know now is Google's take, along with Verizon, on net neutrality. And the proposal that they have put forward that is basically a policy position presented to Washington to tell the world how Google and Verizon think that net neutrality law should unfold and how the regulations should work. This is obviously a big issue, lots to unpack here. Lots of folks have been criticizing this, although Google certainly did its level best to couch this as, we are 100% behind net neutrality and dedicated to it and committed to it. And, here are our thoughts. But buried there in the thoughts were some problematic issues. And Cindy Cohn, legal director over at EFFs, has a great post on this, going through a lot of those pros and cons, as does Dan Gilmore over at salon.com. And it also, this story teaches me better than to ask yes or no questions to the internet, because when I posted over on our Facebook page whether people's spidey senses tingled in response to the proposal that was put out, Andrew Thompson over there merely said yes. So do yours, Corynne, and why?
Well, I think that what was interesting about the proposal, and I think got lost a little bit, there's plenty to criticize in the proposal that Google and Verizon worked out. And we can get into the problems there. There was a little bit that's worth not losing completely, which is the part where they were trying to come up with some way that FCC jurisdiction can be limited to what it really needs to be and not go beyond that. One of the things that we've been worried a lot about is that we don't want the solution to net neutrality to be worse, to basically make the problem worse. And we worry a lot that broad FCC jurisdiction over the internet is where we could end up. And the FCC of today is not the FCC of 10 years from now. How do we cabin in the regulation? And I think that to the extent that it was in the interest of both companies to try to come up with a limited FCC jurisdiction plan, that was a good idea. On the other hand, I think it makes everybody very uncomfortable. The very idea that two corporations get together and sort of set the agenda for everybody else is, of course, going to make everybody uncomfortable.
Right. And it's sort of unusual, as far as I'm concerned, or maybe sort of quaint, for Google and Verizon to get together and say, okay, here's how we feel about it. It's sort of like writing letters to their congresspeople. I don't know what sort of impact this thing will really have, other than, here we are, tax-paying corporations, and we have very vested interests in how this all shakes down. And so, here's what we'd like to tell you about our interests and how we feel you should govern them. A
letter signed by, sorry.
Go ahead.
A letter signed by Verizon is probably different than a letter signed by me to my congressperson. But that's true. I mean, this is just a legislative proposal. I do think that that's something that got a little lost too. It's they're putting out some talking points, and to the extent that is used to set an agenda, then that's worth paying attention to. But this is only the very beginning of what I suspect is going to be quite a long process this fall, fleshing out what net neutrality is actually going to look like.
Mm-hmm. Ben, what do you think about this? Is there something here that is encouraging, or are you basically suspicious of what's going on?
It's a little encouraging that they want openness, and I think the most encouraging part about this is the transparency in wireline broadband, that if they're going to regulate, if there are going to be any traffic shaping or any security measures, or if they're going to try to filter out illegal activity or slow down illegal activity, that broadband wireline providers have to make that clear and publish it somewhere, which isn't happening now. That being said, not a big fan of the rest of it, where they're saying that they can do traffic shaping and even slow down competitor services on wireless, where they're allowing for Verizon, say, to make their own third-party services faster, as long as they're not part of, the open internet. I forget what the exact term they use for that is, but, what Verizon said it was is, let's say they want to send television down their Fios lines, that they can make sure that their television is faster than the rest of the internet, maybe at the cost of the other services that they're doing, which, when you apply that to something like Comcast, is a little more worrisome. How is Comcast going to, assuming these rules get adopted, how would Comcast try to adopt those rules to make, say, NBC content go faster through another pipeline or through another channel, or, how would Comcast try to fit that into, this exception that Google's carving out, that Google and Verizon are carving out in their policy.
Right. And Evan, what do you think? How would it?
Who knows? But that part that Ben was just talking about right there is the part that's most interesting to me, this distinction between the public internet and then these other services, which really wouldn't be a part of the internet. And, Dan Gilmore in his article on Salon was pretty critical of this notion about there being a workaround to net neutrality, essentially by distributing content and transmitting bits on something that's not the public internet. And I really don't know yet how what my feelings are on this, whether that's inherently good or inherently bad, because it does seem like there could be opportunities for real robust content to be delivered, not over the internet. I worry that if we're going to be so fixated on what we think of as the internet now, if our thinking will quickly become outmoded and antiquated, failing to recognize the innovation that could come from what Dan Gilmore is characterizing as a negative potential for a workaround. So it's going to take a while just to let that ruminate a little bit and let that brew. I don't know exactly what to make of that quite yet.
Right.
I think Evan hits on something that's very important. Whatever rules we come up with have to be rules that are flexible enough to deal with the internet of the future as well as the internet of today, and the FCC of the future as well as the FCC of today. I think it's a real problem to try to come up with rules that are that flexible, because we don't know how it's going to turn out. 10 years.
There you go.
Who would have anticipated Sorry?
You locked up there for a second, but you were saying that we have to be careful that the approach toward net neutrality should take into account both the internet of the future and today and the FCC of the future and today.
Exactly. And we're going to need flexibility, because we don't want to all do this. We don't want to do this again 10 years from now, and then 10 years after that, and 10 years after that, right? That's not, or 5 years from now, and 5 years after that, 5 years after that. That's not going to be a very good outcome. So we've got to build in rules that are flexible, that will allow for change over time. And right. I just want to weigh in. I agree with Evan and Ben. I mean, there's a lot of problems in this proposal, and I think everyone kind of agrees on that. There's just, what we tried to do in our post is to try to discern if there was some baby that we didn't want to throw out with the bathwater.
Mm-hmm. Well, that was good. And, I've got to say, that's what I really enjoy about EFF is that, I think that there might be those out there that would disagree with me on this, but I really like the even-handedness that you guys take towards these large issues and the way that you go deep on them and try and present all the sides. Now, some people might say, well, you could say the same thing. I really do appreciate the level of detail and analysis that you guys devote to these hard problems. And I particularly appreciate the 2 posts that you've done this week on the DMCA exemptions that I know that have maybe perhaps begun to fade a bit into the back of people's attention, but that's just kind of a hazard of the news cycle. They remain important, and I'm really, really glad to have you on, Corynne, this week so you can get into them in a bit more detail with us. I have one specific question before we go into your 2 areas you analyzed, which is the exemption for use of video and the exemption for jailbreaking. And that is I haven't been able to quite figure out the retroactive nature of these DMCA exemptions. Do they apply only in a forward-looking way, or do they?
They apply in a forward-looking way. The one thing to highlight, though, is that the cell phone unlocking exemption was a renewal of one that was granted earlier. So that's been sort of a continuation.
Right. Okay. So, but the videographer one is completely new.
That's new, yes.
Right. Let's start with that one first. Tell people now what has changed and what exactly they can do that they couldn't do before this exemption came about, and why it's a good thing.
Sure. So what they can do now that they couldn't do before is they can go ahead and rip their DVD, a DVD that they lawfully bought, in order to take a short portion of it for purposes of, for a non-commercial video, or for educational uses, or if they're making a documentary film. Now, up till now, I think there's been wide consensus that this should really be a fair use to engage in this kind of activity, that all three of those categories of uses were protected by the fair use doctrine. I mean, perfectly legal and perfectly lawful, except you had to circumvent the encryption on your DVD in order to do them, using tools that are widely available, easily accessible. But there was this sort of legal threat hanging over everybody that you might be violating the Digital Millennium Copyright Act because you were circumventing the encryption in order to make these copies. And what Hollywood seemed to think that you should do, instead of using Handbrake, for example, and instead of doing this sort of logical, easy thing, so you can take out a short little bit for your fanfic video or whatever. What Hollywood thinks you should do is you should set up a camera, the movie playing on your screen, and then take that copy and use it, which is just ridiculous. And it was sort of Hollywood thought that we should live in the 20th century as opposed to the 21st century. So now the Register of Copyrights and the Librarian of Congress have decided that we actually get to live in the 21st century and use 21st century technology in order to engage in what everyone agrees are fair uses. So that's what happened. It's great. It means that documentary filmmakers can make their films and not have to worry about whether they're going to have problems getting insurance for distribution, because maybe there's some copyright editors and people who are doing fan fiction, criticism, and making videos that critique or comment on movies that they love don't have to worry about a DMCA violation. And educators in college get to go ahead and take short bits of movies and show them in their classrooms and not have to worry that they might be violating copyright in some way. So it's really a very important victory.
That's wonderful. And that's one of the ones the EFF actually submitted and applied for. Is that right?
We submitted the application for non-commercial videos, and we worked closely with other folks who were in the documentary film community and in the educational community. We all kind of worked together to get this exemption through.
Great. Well, congratulations. And I know another one that folks are very excited about. Well, before we leave that topic, though, let's talk about the tools that are necessary to accomplish breaking CSS. Does this give those tool makers any more freedom or latitude than they have had in the past?
Well, yes and no. With all of these exemptions, they only apply ultimately to the users, right? The jailbreakers, the vidders themselves, the filmmakers themselves. They don't apply to the tool makers. There's no exemption process in the DMCA for the tool makers, which means we have a kind of ridiculous position where the Register of Copyrights has decided that what all these folks are doing is perfectly legal, and they've created a special exemption to make that absolutely clear. But if you make the tools that make it possible for them to do these things, then you might have a legal problem. It's kind of an absurd situation, but there it is. As we sort of say, the DMCA is still broken, but we just made it a little bit better. What is true, however, is that there is a growing body of case law that suggests that if all you're doing is providing tools, that there has to be some sort of link between the circumvention and actual copyright infringement before a court is going to want to hold you liable, you being tool maker. So I actually think that the legal environment has shifted somewhat as a result of these exemptions, such that if we saw a lawsuit a year from now, say, or in the next few months, that was against, say, some Handbrake, or the makers of Handbrake, or something like that, one of the tool makers, I think that they would have a stronger argument than they would have, say, 2 years ago, that they really shouldn't be held liable under the DMCA because they are facilitating what everybody understands to be fair uses and facilitating something that's been made exempt from DMCA liability otherwise.
Right.
So there is a better legal environment. But like I said, we didn't get an exemption for the tool makers because we can't.
Right.
That would be some really interesting litigation to see the defense of the tool makers there, because you would almost have a little issue within an issue, that embedded issue being the fair use of the underlying, whether the underlying use was fair or not. It seems unlikely that there would be a lawsuit brought in the absence of at least one instance of alleged infringement being occasioned, or one instance of there being a distribution and use of the anti-circumvention technology in there. So it could get pretty complicated, it would seem, relatively quickly, with a lot of little vignettes within the larger case.
Right. Well, I imagine if I were someone planning to bring one of these lawsuits, I'd be looking for the best facts possible. So I would try to find something that wasn't where the underlying use wasn't so clearly a fair use. But nonetheless, I think it's at the very least, you're going to be able to say that this technology is capable of substantial non-infringing uses, and everybody understands that, including the Register of Copyrights.
It's like the law saying that smoking is legal, but making cigarettes is not. So have fun rolling your own, basically.
Yeah, it's a little like that.
And also, I mean, I'm looking forward. It seems to me, just following up on what you said, Corynne, that what EFF is going to look for in looking for a lawsuit to get involved in along these lines is one where the fair use is very clear cut, and you want to go ahead and say that you should be able to facilitate someone's legal activities through your own activities.
Well, I think that certainly makes for a cleaner case. We don't have to worry about, because I think it's quite right. You don't want to spend your lawsuit fighting over whether the underlying use is fair or not. Let's set that aside and focus on the pure DMCA circumvention issue.
Exactly. Ben, any thoughts on this and what we should all be smoking for the rest of the show?
I think you guys covered it pretty well. The only question that I had was, Corynne, the line of cases you were talking about, are you talking specifically about the dongle case? It came out a few weeks ago that if you circumvent an effective copy protection measure but then don't actually infringe a copyright, you haven't violated the DMCA?
I'm thinking about the Skylink and Lexmark and then MGE Entertainment cases. I sort of think we have sort of a trio now.
Mm-hmm. Right.
The Chamberlain case from the Chamberlain case from the Seventh Circuit, even I think that was around 2002, kind of hinted at that. A lot of times.
Yeah, that's what I meant by the Skylink case.
The garage door opener case. Right?
Yes.
I think there's a place where you can, if you get the right judge, that you can get them to sort of see reason. I think that there's judges like common sense solutions. And I think that judges are understanding in the copyright sphere, not just with respect to circumvention, but in other areas, that there are a few things that are fundamentally out of whack.
Mm-hmm. All right. Well, the same applies to the jailbreaking exemption. You can jailbreak all you'd like if you're a user, but if you are somebody making an application that accomplishes that, beware. Isn't that right?
That's basically right. It's still broken for you. Like I said, though, but I do think the legal environment has changed. And one thing I would point out is that as a practical matter, I don't think that Apple is that interested in going after folks that provide this kind of software. Mm-hmm.
Well, that's
at least they haven't so far as I know. And, who knows what they would do tomorrow, but I think Steve Jobs has bigger fish to fry.
Yeah, if nothing else, these are just great ways for Apple to find security holes in their software. Every time they release an update of the operating system, somebody finds a security hole, jailbreaks through it, and then Apple patches that. It's, effective on Apple's part not to sue these people because, they almost don't want to deter them from finding these new security holes.
Right, and for the great mass of people who don't jailbreak their phones. It's just a way for them to patch those holes and move ahead. Any other nuances of the jailbreaking law? You have a nice long post on this on Deep Links, Corynne, that you want to highlight for us today?
Well, one thing that a number of folks have written to us and said, well, but what about the warranty? So, you know, is it right that I might still void my warranty, or I might have problems with my terms of service with Apple and so on? And so one thing to just be clear about is that, so this takes away one legal issue, but you still may have contractual or Apple can still impose contractual and technical restrictions on you if it chooses to do that, right? And that's, the DMCA doesn't have to do anything to do with that. What it does make possible is for you to choose what you would do. For example, when you buy a car and you decide you don't want to take the car to the registered dealer for servicing, right? Sometimes that might void your warranty, but you may, as a consumer, decide that that's something you want to do. You can do the same thing with your iPhone now.
We took a look at the Magnuson-Moss Warranty Act. I think it was on the last show, and kind of noodled about whether there might be some wiggle room there on what Apple was allowed and not allowed to do with respect to honoring consumer warranties. Do you think it's pretty cut and dried, or that they might actually find themselves in a situation where someone is saying, hey, you know, I haven't done anything that actually broke the phone. This actually fixes a problem with the phone as far as I'm concerned. So honor my warranty. Do you think that would go anywhere?
You know, I don't know. I haven't looked at the Magnuson Warranty Act, so I have to look at it. So I really don't. I really don't know. I'd be
TWiL listener sent that one in.
Yeah, that's I should seriously. I will look at that. Thank you for bringing it to my attention.
Yeah, I put the text of it in our show 73 show notes, and there is a little clause there that says, you know, if the consumer does something that breaks the device, then I forget exactly the terminology. It's not actually the word break, but damage.
I thought it was cause damage or is an unreasonable use of.
Yes, that's it.
Right.
So you know, I think there's something to talk about there.
And I will say, as a practical matter, I've jailbroken phones and then brought them into Apple for service, and either Apple hasn't checked to see if I jailbroke it in the past, or you know, they've just replaced it, you know, without even, you know, I had a hardware issue and they, you know, found the hardware issue and just replaced the phone right out. So I don't know how hard they're looking to enforce the even the warranty issues with regard to jailbreaking.
Well, that's good to know. Evan, any thoughts on jailbreaking or video or the exemptions in general?
I don't think so. I mean, the warranty issues we're talking about here are the ones that have come up in conversations that I've had about it, not calling them warranty issues, but calling them, you know, just contract issues. And, you know, clearly the DMCA does not obscure, you know, the potential for liability in terms of breach of contract or a loss of rights and remedies in terms of voiding warranties. So it's been a nice, tidy discussion about it.
Great. Well, as long as we're talking about phones, of course, EFF is quite concerned about privacy issues. And why don't we link those two things up? There's a good article by Ron Kalari over at InventorSpot about privacy leaks in free applications for iPhones and Androids. And again, I think this is something that EFF has been following pretty closely. And it's an interesting area of the law because, again, as things evolve and we're using the web on other devices and we are connecting to networks in various ways other than from our desktop computers, I think privacy law is confronted with a bunch of challenges, too, that it hasn't faced before. And one here is, of course, that a free application, in order to justify its price or lack thereof, may be collecting data from you that they are not terribly straightforward about disclosing. Let's see. Let's start with Corynne. What do you think about this? And do you think that our privacy laws are equipped to protect people's interests here?
No. But
okay. There I go asking yes or no questions again.
Well, but I think here's what I worry about. I mean, I do think there are some good, strong privacy laws that we have in place, and whether they actually get enforced is another issue. But I think that as a practical matter, what's really going to, if people want to protect their privacy, they're not going to be able to just rely on the law to do it. Consumers are going to have to educate themselves to protect their own privacy. And, through encryption, through making sure they set their privacy settings the way they need to try to avoid, downloading stuff that'll invade their privacy. The problem with that, I just think as a practical matter, that's your best line of defense. The problem with that is most consumers aren't educated enough to do that. And frankly, don't want to spend the time. It can turn into actually a fair bit of time to protect your privacy. And that could be sort of burdensome for consumers. But really, that's going to be your best line of defense.
Evan, do you think that the privacy laws that require free sites such as Google to have privacy policies and tell people in advance what sort of data they are collecting, that they apply to the new mobile device world? And if they don't, what are we going to do about it?
Whenever this topic comes up, I always think of the California statute requiring commercial websites to have privacy policies, because in my practice, even though I'm here in Illinois and I don't represent too many California companies, I think everywhere outside of California, we think of that California statute as kind of the de facto federal standard, because most websites are going to have end users within the state of California. So I guess one of the threshold questions then is whether this type of practice would come within the scope of the proscriptions and prescriptions of that statute. My natural impulse is to think of this in terms of what the Federal Trade Commission would be interested in and what kind of disclosures they would want to make sure that end users have, how they're informed as to how their information is going to be used and shared and assimilated and linked up with other with other data points across the internet. And as we know, the FTC's jurisdiction is much more malleable, much more in the same vein, much more nebulous. It's not really clear. The concern is that the FTC is just going to be this roving enforcement body that just can look at things very willy-nilly because of its broad enforcement powers under the Act. So that would be where I would look for the most concern in things like this. If I had a client who was presenting a set of technological standards and protocols to gather information without making it very clear to the end user, I would be much more concerned about what the Federal Trade Commission would say about this under its general powers than more specific things that speak particularly to privacy policies. And
just to complicate things, as Mr. Kalari points out here in his article, that it's not necessarily the app distributor who knows what's going on here. It may be some component, some software component they've included in their app that collects information without even warning the developers. So you may have a few different layers of what goes into the recipe for the mozzarella, as we were talking about with Ben before we went live here and started recording. There are a few different ingredients in the mix here, and you may not know what all is going on. Of course, if you're distributing an application, I think you're going to be held responsible for what it does, no matter what its component parts are. Ben, do you have any thoughts on this?
Only to say that your first line of defense for these things is often, you yourself. With iPhones, at least, if there's an app that wants to access your location information, it'll ask for it. Ask if you'll allow it to access that information. You don't have that same protection, unfortunately, with apps that try to access your contact list. At least, not that I've ever seen. Usually there's some active component in it, but there may be some back-end way around that. But, keep an eye on it. And if you downloaded an app for free and you're playing it and it asks to access your information and you don't see any reason why you should, don't just click OK. There's There are a lot of things that people individually can do to protect their privacy, and I feel like a lot of the time they just click OK on whatever pops up, thinking that the app will work better, or don't really give much thought before they click on it. So keep an eye out for those things.
Right.
I mean, it's kind of funny. It's sort of like when you buy when you go to the store and they ask for your zip code. How many of us just hand over our zip code without asking, why do you need my zip code?
Most everybody does. I never do. I mean, it just ticks me off when they do that. But, I'm probably more paranoid about those things than most. And that and the verification of your credit cards with your driver's license has just become completely routine these days. And that one, again, I put on my tinfoil hat and say, okay, you can look at my license, but it's not leaving my clutches. You can look at the number. You can look at my picture and my signature. But, Cory Doctorow has put the fear of God into me with magnetic strips and how much data they can contain. And so forget it. You don't get to swipe the thing. Right. I don't know. Hey, thank you to Virgil in the chat room for letting us know that Google has actually come out with a statement that they gave to TechCrunch. There's a post over there by Jason Kincaid about the Oracle suit, and they're saying, we are disappointed Oracle has chosen to attack both Google and the open source Java community with this baseless lawsuit. The open source Java community goes beyond any one corporation and works every day to make the web a better place. We will strongly defend open source standards and will continue to work with the industry to develop the Android platform. So there you go. They seem to be signaling they are going to take a principled approach here and go forward in that way.
It's really no surprise that they would couch it in those terms, because it's clearly going to polarize the issue much clearly. If you read the complaint, it mentions nothing about open source. Even the copyright section doesn't mention, the claim for copyright infringement doesn't talk about the GPL or anything like that. So we all know how exuberant and enthusiastic, I guess is the word I'm looking for, people are in this space of debate, exemplified by the multiple exclamation points you described in that entry in the chat room a while ago with the guy talking about, or the user talking about GPL3. Couching it in those terms is clearly going to rally the troops to one side or the other, rally the supporters.
It will indeed. All right, well, we're talking about privacy leaks from phones. Evan, you sent in a story for us that is loosely related to that topic. And it is a fellow who was riding along on a public mode of transportation somewhere and doing nefarious, lewd things in public. And one of his fellow passengers was not pleased with this and wanted to see him brought in, at least probably removed from the bus at any rate, and tweeted his photo. And sure enough, they were able to come up with his identity. A pretty funny story, Evan. Why don't you fill in any blanks I've left out?
Right. Well, I like this story because it's a very succinct example, a very practical, discrete example of a general principle that we talk about a lot, and that general principle being distributed information and distributed perceptions of things, people being out there seeing what they see as members of society and recording them and sharing them. We see this more with mobile technology. So it was a guy riding the subway, either the subway or the bus in Boston. I don't know, does Boston have a subway system?
They do.
Yes, it does.
Yeah, there's some big project. I knew that there was something going on out there. So I've heard about it once in a while.
We just have the oldest subway in the United States, sir.
Oh, is that it? Is that it?
Yeah.
Okay. I'm kidding. I knew there was a subway there. Took a picture of the guy, and it would be so difficult to share that information without the technology that we have now. So by putting it to Twitter, this was a wonderful way of distributing that, and to make a happy ending for it here. The guy was caught. It turns out he was a repeat offender. Then it just showed his face. It didn't show what he was, the lewd act that he was committing.
There was no high definition video of what was going on. That would have been possible in many instances too.
Right. And I bet in this situation, we can all be grateful for the fact that wasn't utilized. So I just like this for the principles that it encapsulates. Being out there and being distributed, and mobile technology and all of this stuff actually causing some favorable result to the benefit of civilized way of living.
Right. So what was tweeted out was a photo of him and something that said, "Pervert on the second car of the red line, help me report him." But then I'm not quite sure, how they closed the loop on that. He was arrested Friday for open and gross lewdness, according to a statement from MBTA police. Did someone recognize him? Did they do some sort of facial recognition? I don't know. It's kind of fascinating that just a photo strewn on the waters like that could actually lead to an arrest. Does anything about that set off any red flags for you, Corynne?
Well, I think it just sort of points to the reality, which is that everywhere is public now. Mm-hmm. Or I mean, even your own house, if you don't shut your curtains, you could end up on Google Street View. So you have to.
And people have.
Very hard. And their cats have. And their cats have. And our very own Kevin Bankston was caught on Google Street View smoking outside of the EFF offices. And not everybody knew he smoked, but everyone knows now. But there is a place where that's just a reality, and I think that a lot of folks are still struggling with that for understandable reasons. That I think of my grandparents, they would just be appalled at the notion that there was no private space. But that is true. And one thing it makes me think of is I've been in some discussions with the organizers of the Burning Man Festival, which is an enormous festival that happens in the fall in the Black Rock Desert outside of in Nevada. And it's 50,000 people go now. It used to be a small festival. Now it's 50,000 people. And there's a lot of concern about people taking pictures because everyone likes to think that what happens at Burning Man stays at Burning Man. And people get kind of wild up there in the desert. And there's a lot of concern on the part of the organization to try to protect the privacy of the participants. On the other hand, there's a reality that there's 50,000 people there with mobile phones. And that means there's 50,000 people there with cameras. And it's very difficult to police privacy in such a context. And there's sort of a question about whether it's even possible. Whether there's a point where you just have to say, what happens at Burning Man isn't always going to stay there.
Right. And I'm going to put my foil hat back on here for a moment. Burke in the studio tells me that it might look funny, but it never hurts. And what I'm thinking about right now is last night, in fact, I started using the Faces feature in iPhoto, the feature that, you go through your photo collection and identify who is in it. And it works really, really well. It's kind of scary and freaky how well it works. And as I'm going through and doing it, I'm thinking of the great convenience and how I'm really going to enjoy being able to sort my photos that way. But of course, I'm also thinking of the volume of data and the kind of data I'm creating, and then the kind of data that's actually collectible, presumably by Apple. I don't know if these applications phone home or not. But it gave me pause. It gave me the sense of, the FBI probably has so many more sophisticated ways of doing this. But if you were to crowdsource this to everybody just working with their home photo applications, think of the database you would develop. And I don't know. I mean, again, I'll take off my hat now. But
I've often wondered, Denise,
yes,
how well Faces would work with an extremely large database of people. It works very well for you and your social group. But if you tried to feed in, 300 million faces, would it still be as robust? Would it, would it generate a lot of false positives, or would it, just collapse under the strain of trying to distinguish between that many people?
Yeah. No, I'm sure that, it's not a perfect identifier of people by face recognition, but people are pretty good at doing that. And just the notion of, if this is the norm that people become used to of going through and IDing their photos that way. And of course, Flickr does that too. You can go in and tag people on Flickr that way. that you get a lot of bang for your facial recognition buck by crowdsourcing the activity. I don't know. Just toss that out there as I muse about the poor Boston guy who got nabbed by his co-writer. So thanks for submitting that one, Evan. Let's look at some other social media related stories. This one I thought was pretty interesting. I have a couple of links in the show notes about social media use in the workplace on the rise. Mashable has a great post on that, how social media has prepared us for collaborative business. But of course, when we stop collaborating is when we leave one company or one employer and go on to another. And there is a non-solicitation suit that has been filed concerning LinkedIn and use of LinkedIn to violate the terms of somebody's non-compete and non-solicitation agreement when they parted ways with their company. And I think that it's a pretty interesting question, the whole notion of, when your contacts live online and not on some employer service server locally somewhere, when they really become more your contacts, your business contacts, that it's difficult even by agreement to carve that out when someone leaves. And we had a comment, an email from viewer Ron Nixon a while back who had a twist on this involving mobile phones and Google Voice. And he writes, I was having a discussion with a neighbor of mine who had explained that he once worked for a company that issued him a mobile phone. He had given all of his clients this mobile's number to reach him. And to a few clients, he had given his personal mobile number. When he left the company for good, only a couple of his former clients followed him to his new company, which of course could be problematic down the road. But Google Voice allows you to forward your Google Voice number to any phone. So I can easily see that if I were given a mobile phone to conduct company business, I could easily pass out only my Google Voice number to all my clients, have that Google Voice number forwarded to the company-issued mobile device, and if or when I leave the company, all of the clients would still have access to me and not the company. So just a bit of a twist on the LinkedIn case here. And I'm wondering what you guys think of this. Evan, do you think that employee contracts need to be a bit more expansive and take this kind of thing into account? Or can they even take this kind of thing into account?
Clearly, if you're looking at the interest of the employer, you would want to try to make them more expansive and to take these things into account. But the technology presents a set of circumstances that pushes this more toward the borderline of absurdity. And the real problem becomes one that arises from the tension that is created when you try to regulate information in this way, exert ownership over information. Clearly, a list of contacts in most circumstances, the overwhelming majority of circumstances, is not going to be within the domain of copyright, so we can put those things away. Really what it comes down to is either a trade secret owned by the company or just some kind of ownership of this stuff through a restrictive covenant in an employment agreement. And it just becomes so odd to have a company exert ownership over something like this because, really for two reasons. One, because the nature of what is trying to be owned here is so slippery that, the information, that how do you own that? It's not something tangible. It's not really chattel-like. The other reason that it becomes problematic is because the relationship of the information to the agent in the system using that information, that being the address, email, or the email address, the name and the phone number of the contact, that the relationship of that to the employee is something that is outside of the umbrella of the company to begin with. So even if there is a restrictive covenant that purportedly governs the use of that information, it just becomes very strange and very odd and very strained because of that tenuousness arising from how the information is actually used in the real context of things. That's what I think.
Right. Yeah, it's an interesting twist. Since the Mad Men days, there have been issues between employers about an employee's Rolodex, what comes into the door and what goes out with them when they leave. But now in the day and age of the social graph, I think it's really hard for me conceptually to get my head around a company asserting an ownership right in that. Corynne, do you have any thoughts on that?
Well, I think that Evan's quite right. There's no question that they don't own it in the sense of having any kind of copyright claim. And these are facts. Mm-hmm. You can't own facts. So that's easy enough. But in terms of trying to control it, I think you're quite right. It just seems as a practical matter. We don't have Rolodexes anymore. We have Facebook pages, and people may have 4,000 friends on their, Facebook friends. And how do you know? Some of those will be professional, some of those will be social, some of them will be both. I think another thing, too, is that as we have an increasingly mobile world where people move in and out of jobs, sometimes quite quickly, it's not always going to be easy to discern whether someone's a purely professional contact as opposed to a personal contact. So trying to parse those things is really difficult. My thought was just as a practical matter, I don't think it's so very easy, even if you wanted to distinguish between personal and professional contacts. Certainly I have many, many contacts that are both personal and professional, and to go through my address book and try to distinguish the two would not be easy. Yeah. And I'm sure it's true for many people.
And I think that people are becoming more savvy about the things that are in their employment agreements when they sign on and in the employee policies that they're asked to abide by. Maybe, I don't know, maybe I'm just dreaming and people rubber stamp these things, but
I think you should take a poll and see how many people
if someone comes to you with an agreement that says you have to unfriend everyone that you've made while you've been an employee at the company, I think people's alarm bells are going to go off.
Yeah, unfortunately, they're probably not even going to be paying attention, because you know how it feels when you get a new job. It's all just warm and fuzzy feelings, and oh my gosh, look at this salary. I mean, I get, in an ideal world, that's how it works. I mean, you're usually just looking at you're usually just looking at the positives, when you're taking on a new job and when you would be agreeing to these things. And
right, and in this economy, you're probably just looking at having a steady paycheck. Ben, right, what do you think about the Google Voice permutation on this? I'm sure that companies have policies that say thou shalt not use Gmail, Google Voice, outside services, what have you, but people do.
Yeah, I think it's really interesting. I had actually never seen a non-solicitation clause before I read this story, and the way this one is written in this story is that it would prohibit the woman who's accused of violating the non-solicitation clause from contacting any clients or colleagues if she left that company. So she wasn't allowed to, if it's actually written that broadly, to call up a friend that she made at the former company who's still working there now that she's moved to the new company. What it doesn't really make clear is if those people contact you, is that okay? And that's where I think the Google Voice thing comes in. And, if you're tricky enough to set it up so anyone who calls that old number gets you, if they're contacting you, you may get around it. I don't know how kindly a judge would look onto that argument, especially if you intentionally set it up that way, knowing that you did it to get around that provision of the contract.
Right. Well, speaking of people using social media for their work and personal lives, there's a post over at TechDirk from Mike Masnick about a finding that here a judge dismissed 2 claims against parents for not controlling their children's activity on Facebook. There was a private Facebook group that unfortunately was making fun of a student. There were only 6 students that were members. The student who was the target somehow discovered what was going on and sued the classmates' parents. So this is shades of other litigation we've seen about cyberbullying, et cetera, on social networks. But here the judge dismissed both claims and noted that the Facebook comments were puerile attempts by adolescents to outdo each other. And while they displayed an utter lack of taste and propriety, they do not constitute statements of fact. So there go the libel claims. And they basically just didn't find any liability whatsoever for the parents on the children's behalf, which as a parent, I have to say is relieving. And as a copyright person, I have to say is interesting because it's certainly not the way that the P2P lawsuits have gone. Corynne, do you see a parallel here? And why does copyright law work so differently than this?
Well, I think what happened in the peer-to-peer context, though, too, is that it was not always easy to distinguish between whether the parent or the child was engaging in the activity. So actually, I think there is still a credible argument that if you and there's some case law on this, that if it's proven that in fact the parent is not the one who engaged in the file sharing, that they shouldn't be liable. As a practical matter, a lot of parents are not really willing to throw their kids under the bus that way. So I think it just doesn't get raised. But this is a different kind of context. And I think what's interesting about this decision is that the court focused on the term dangerous instrument. And I think that's very nice. As Masnick points out, a computer is not in itself a dangerous instrument. And so it may be misused in various kinds of ways, but we're not going to treat it as a dangerous instrument itself. It's not like giving your kid a gun. It's just giving them a tool.
So that, just to clarify for our listeners, that would be the standard. If you gave your child a dangerous instrument, then you might be responsible for their actions?
I think that was the standard here. Now, this is probably a matter of state law, so it's going to vary from state to state. But as I understand it, the theory here was that you just use traditional what are called tort principles to figure out whether tort law, whether the one person's responsible for the activities of another, and one of the ways and parents are often responsible for the activities of their children. But I think the determination here was, first of all, they're teenagers, and in this kind of and under the prevailing law here, it's just that if you give them, if you participate in the activity, if you facilitate the activity by giving your kids a dangerous instrument, then you could be held liable. But the courts tend to want to retreat from the notion that parents are going to be liable for everything their children do. There's got to be some kind of limit. And I have to say, also as a parent, I'm also glad about that.
Yes, absolutely. Evan?
It would be really interesting to see Section 230 raised in this context, because Section 230 provides immunity for providers of interactive computer services. So in this scenario, it seems like one could argue with a straight face that the parents, by paying the bills, for the internet service provider, are the providers, the intra-family provider of an interactive computer service for the children. And, so they are the ones who are, it's the information provided by the children who are the other information content providers, which would seem to place the parents as the providers here and users of an interactive computer service, a downstream user, within Section 230's scope of immunity.
Oh, I like that. Yeah,
that
you're right. The definitions under Section 230 are pretty broad, so that's an interesting point. Ben, any thoughts on this?
No, not really. Just that this is a weird thing. It seems to be a weird dichotomy between negligent supervision, what the suit was brought under, and negligent entrustment, which is not being very familiar with New York law. I can't really comment that much on it, but it was certainly a novel claim on the part of the plaintiffs to say that the parents somehow either negligently supervised their children in letting them use Facebook or negligently entrusted them with a dangerous instrument that is a computer so that they were reasonably likely to know that their children were going to harm someone with it.
It is a practical matter. If you think about it, if they had won, where would that put parents? That would put parents in a position of having to police all of their children's communications online, which, we like to think that even teenagers have some kind of privacy rights. So it seems we'd have a direct collision there.
Yeah, although I don't know. I mean, I'm on the PTA at our school, and And the vibe I get from other parents is they feel like there's that obligation that, you know, if your kid is, I'm glad this case came out the way it did, because I think that there's sort of a mob mentality out there that if your child is engaging in something that, you know, might be free speech and maybe not very nice, but still within their realm of privacy and bad judgment, that the parents should be stepping in all instances. And so it's nice to see that this case came out the way it did. And as Mike notes, there is no cyberbullying statute in New York, so that's why they had to go under standard old reasonable person tort law.
But, you know, the one thing I would say about that is we learned in the file sharing context that if you try to supervise too much, or, you know, what I could see happening is that kids will just start encrypting their communications. I mean, it's, you know, if teenagers are smart enough and creative enough to find ways to avoid their parents' prying eyes. And this too makes me nervous as a parent, but I think it is true in reality.
PIR, parent in room. Absolutely. So it's, whether they're children or adults, lots of people are being targeted in these copyright group lawsuits. And Corynne, you actually went to Washington and made an argument there against the mass lawsuits. You want to tell us about that?
Sure. So we've been very concerned about what we've been informally calling spamigation. And it's not just in the context of the U.S. copyright group lawsuits, but there's some other folks. There's a Right Haven group and a new one that I just read about yesterday called the Copyright Defense Organization, all of whom are engaging in these kind of mass copyright lawsuits. And what they do is well, let's just focus on the U.S. copyright group because they're the most egregious. What they did is they brought a lawsuit against 7 different lawsuits against a total of 14,000 people in one court, including one lawsuit that all by itself was against 5,000 Doe defendants. And they bring these lawsuits and then they issue subpoenas to internet service providers based on the lawsuits. And they get the identities of all these people that they allege have engaged in unlawful use of BitTorrent to download movies. And our concerns about this were really just that this is not a fair process, that this is an abuse of the judicial process. Under normal due process principles, you don't go and sue 5,000 people at once, all of whom are likely to have, you know, very different facts and circumstances, to not be related to each other at all, and they shouldn't be what's called joined together in one lawsuit. So that was one problem. It was also clear to us from the evidence in the record, put in the record by the U.S. Copyright Group itself, that the District of Columbia didn't have jurisdiction over all of these people. And so they had no business suing them all in the District of Columbia when they had information that these people, based on their IP addresses alone, or the IP addresses they had gathered in their investigation, these people were located in Maine, they were located in Hawaii, they were located in Florida, all over the country, and certainly not in the District of Columbia. And it's not fair to file a lawsuit in the District of Columbia and then force a defendant who wants to, for example, protect their identity and have their identity not be revealed, force them to have to defend themselves in the District of Columbia, right? Potentially 3,000, 4,000 miles from where they actually live. And in fact, the plaintiffs aren't even in the District of Columbia. The only person that was in the District of Columbia is the law firm that's representing all these people, the Dunlap firm, which is also calling itself the U.S. Copyright Group. So we went to Washington to talk to the judge about this and to explain that there was a fundamental process problems here. Our concern here is, setting aside whether anyone is in fact liable for infringement or not, the defendants have a right to be treated fairly, even if they've, even if they're copyright infringers, which of course is only alleged at this point, it's not proven. But the point is, everybody has a right to a fair process. Our Constitution guarantees it, and we asked the judge to help us to intervene effectively to make sure that the process was fair for the defendants.
Yeah, these Right Haven suits are really scary. This is one little group in Las Vegas, and there's a post over at Threat Level about this by David Kravitz. A lawyer named Steve Gibson has decided, patent trolling is working really well. Let's try it in the copyright model. And his target clients are newspaper and media companies who, of course, their snippets of work appear all over the web all the time. And he has made it his project to say, hey, you guys have rights, and we'll go out and find those unauthorized reuses of your publications, and we'll go after these, nefarious bloggers or whoever they may be. And it's a big stick to shake at someone who's posting on the internet. I presume, they would shy away from bigger, deeper pocket defendants. So this one seems, quite scare tactic-y. Evan, have you taken a look at this?
I did, and those efforts seem so disproportionate in comparison to the alleged harm suffered by the plaintiffs in these situations. You can almost see the rationale of the RIAA in its campaign, its litigation campaign that started back in 2003. He said you can almost see the rationale. I mean, now that the numbers are out, the proof was not necessarily in the pudding that it was effective. They spent something like, in 2008, they spent something like $17 million and recovered $390,000 or something like that. But you can almost see the rationale for going on that kind of litigation campaign because of the numbers of works that are being distributed and the numbers of works that an individual defendant may be accused of infringing. In this type of situation, based on common sense, or at least on my experience with these types of things, it would be unusual to find a defendant who is a serial infringer of a bunch of articles from one newspaper. Maybe I just don't read enough blogs about local politics and stuff like that, because I can imagine there could be some situations like that. But to me, the ordinary defendant would be somebody who happened to just copy an article from this Las Vegas newspaper or something like that. And if you're going to be writing them cease and desist letters, and if those efforts are unsuccessful, then filing a complaint in federal court over one or even a small number of articles, trying to extract a few $1,000s from that as a result or in response to the defendant being scared, that just seems so disproportionate to the harm that the paper would suffer, having one or two, just a few articles reprinted on a blog somewhere. So I admire the guy who's doing this to the extent that he's trying to be innovative in looking for business models and being a plaintiff's lawyer. But when it comes down to the soundness of it,
I'm not a fan of the innovative vest and khakis, though. There's a big picture of him on threat level.
Yeah, right.
Guy needs a wardrobe consultant. I
learned having gone to a college that was all male. I learned long ago I am not going to be an arbiter of fashion because I just, am not. So it's good to see somebody being innovative and thinking of the ways they're going to develop a business model around this. But it's really unfortunate to see it be so disconnected with any damages that need remedying here.
Yeah, I'm making light of this, but it's not a light thing. I think the return on investment here is potentially very high. That under the Copyright Act, they have a very big sword to shake over people's heads, and they have a model to follow. I mean, as you say, the RIAA did not exactly rake in a lot of money from its lawsuits, but it did consistently settle for a few $1,000s a pop. And this is just so chilling to fair use, as I imagine people going ahead and ponying up just to make the lawsuits go away. Ben, any thoughts on copyright trolling?
I don't have a problem with these lawsuits if they're going after the kinds of sites who, copy articles wholesale and repost them on a blog with, Google ads on the side. But from what I'm reading, it's not really clear if they're doing that or if they're going after bloggers who are just taking snippets. There's a real clear difference between people who at least think that they've got a fair use, or if they knew about fair use, would think that they had a fair use right to use a snippet of an article, and going after, the people who are out there intentionally trying to make as many websites as possible to get people who accidentally click over there and then, click through the ads. The latter, again, don't have a problem with. The former, it would be worrisome if they were actually getting the number they said in the article is between $1,500 and $3,500 settlements out of these lawsuits.
Yeah, unfortunately, the sploggers would be far harder to find and sue. I think they're probably taking more intense steps to cover their tracks than just the general person spouting off on the internet. All right. Well, I want to get to our resource of the week, which is going to be EFF's Fine YouTube account, which you can access at EFF.org/YouTube. There are a couple of great PSAs up there that I thought we could play for you guys and let Corynne offer any comments that she wants to, as well as, of course, Evan and Ben. Burke, if we're ready with one of those, let's cue it up. Sorry?
I can't see them. Oh, there we go. Okay.
Oh, you will in a minute.
I need you to sign here and here to read the book.
Oh, yeah. I love this one.
This agreement.
But I just want to buy the book. Why do I need to sign anything?
Yeah, I love that one too. So the point being the contrast between digital books and what you have to agree to, and of course when you just walk in and buy a real world book.
Right, that's something we've been very concerned about.
That's a cool fabric pattern on that couch.
And here's the
nice in the living room, but the couch is going to shed all over it.
One.
Looking for a new couch? We have great deals this weekend at patternonThatCouch.com.
We have some great fabric patterns here at GreatFabricPattern.com.
We have a special today on non-shedding, hypoallergenic, organic, free-range kittens at FreeRangeKitten.com.
Now, why don't you get me one of the rings of
So those are great, Corynne. They really do a nice job of getting across the message that people should be paying attention to these things that we all just kind of take for granted. Who does them for you? Do you know?
We had a group of students actually who did that for us, and working with Professor Eric. Oh, I'm blanking on his last name. Sorry.
Goldman, maybe?
No. No. Oh, darn. Well, anyway, there were a group of students who did that for us, and we were so impressed. They did such a fantastic job, and really in sort of hitting the issues that we worry about a lot.
And there are tons more great videos up there, including folks at DEF CON getting mohawks. One of your EFF people getting a mohawk in solidarity, and she was a woman, in solidarity with...
That was above and beyond the Call of Duty. We were very impressed.
Absolutely, and it was quite a stylish one. You know, it wasn't just this narrow stripe of hair down the middle. They kind of gave her a little flip.
Oh, she looks great.
So, yeah, it does. Do go check out our resource of the week, which is youtube.com/EFF.org, where you can find all kinds of good video content and offerings from EFF. And of course, if you're liking what Corynne and EFF are up to, you can go to EFF.com/donate and tell them so with your wallet, because as there's a little endorsement from Corio Doctorow over there saying that they do so much with so little. And I think that really sums it up. So as far as the issues covered by those PSAs, the tracking, which I actually wrote down in my notes as digital trafficking, which I thought was a good Freudian slip, because of course, not only are you tracked, but then that information is sold, and that's really the dangerous and problematic part of it all. And there's been a great series. Have you guys been paying attention to this series in the Wall Street Journal about what they know?
Oh, yes. In fact, our very own Peter Eckersley has been quoted in a few of the articles.
Mm-hmm.
And it's been a great series. It's been, I think, extremely informative, and I think anyone who's not reading it should be, because it's quite chilling, actually.
Yeah.
Even I learned some things that I didn't know, and I like to think that I keep up on these things professionally. So consider how much you might not know about if it's not your job to worry about this all day long.
Yes, so that'll be our secondary resource of the week. Everyone go check out that What They Know series in the Wall Street Journal if you're not already reading it. And I do have a tip of the week, and the tip would be if you're going to go ahead and sue Google and YouTube for their infringements of your copyrights, don't violate protective orders and leak out sealed deposition transcripts from Eric Schmidt, where he is musing about the valuation of YouTube. And just don't do that, because you're going to have to wind up probably paying Google $20,000 and dropping your suit against them. And I'm talking about a guy named Bob Tour, who's been after YouTube for a long time and recently got... there was a motion for sanctions against him that the parties settled. But yes, he had to pony up $20,000 to YouTube and go away as a plaintiff. So do listen to your protective orders, people, when you're involved in litigation. And Evan, did you check that out? Any thoughts on Bob Tour? We've certainly seen him around for quite some time. How the mighty have fallen. Wasn't he yet? He was the first on the scene, wasn't he, with these suits against YouTube? So, and it actually just kind of went away with a whimper. I mean, this whole story, when they started suspecting it was him a couple months ago, it kind of made it under my radar. So when we were looking at the notes for preparing for today, I was like, oh, that Bob Tour. Bob Tour. Yeah. So, good idea to those protective orders usually serve a good purpose. Even if they're not your purposes, the judges don't like it when those are violated. So that's great advice to anybody involved in litigation. Right. And even if you're leaking to Greg Sandoval at CNET, who, of course, we love his work and have had him on the show and love him to get a good scoop, but be careful. Yeah, I mean that wasn't very nice to put him in that spot of being at risk in the hot seat as well, Yeah, so. He would have had to disclose his source probably if it hadn't come out anyway. Or tested the shield laws in California. I'm sure you'd have had a little bit of help with that. He's with CNET, right? And they have the whole power of CBS behind them. So they do indeed. They do indeed. All right, folks. Well, let's go around once. And if any of you have any thoughts or final comments on the stuff we've talked about today, let's start with Ben. I'm all set. Just want to say it was great talking with everyone today. It was great having you. Really appreciate you coming back on the show. Of course, folks can find Ben and his Technically Legal podcast at technicallylegal.org. He is at Snitty on Twitter. That would be SNITTY. Yes. And we enjoy the blog, we enjoy the podcast, and really have enjoyed your insights here today. Thank you. Great, thanks. Also, Corynne from EFF, which of course is on Twitter at EFF. And Corynne herself is there with a woefully sad and empty account. Maybe we can encourage you to post, Corynne, if we get you some followers. She's CMCSHERR at Twitter. So go follow her up. And we really, really appreciate all your thoughts and explications of some very complicated and important issues today.
Well, thank you very much. And let me say, don't follow my Twitter account. Follow EFF's Twitter account. That would be much more interesting for you. And one last thing, I just wanted to go ahead and give a shout out to the students who did those PSAs. We're working with Eric Faden at Bucknell University. And I strongly urge you to Google a fair use tale to find some other work by him. That's just fantastic. So not a shout out for me, but a shout out for Professor Faden. Oh, yeah, absolutely. I remember the fairy use tale. It's a few years old now, right? It is a few years old, but it holds up. It's just great. It's funny. Yeah, good stuff. And thanks very much for having me on the show. This was good fun. And, of course, Corynne posts regularly to EFF's excellent blog, Deep Links, which you can find at EFF.org/deeplinks. Evan, thank you so much for coming back on and for our wonderful story about lewd conduct in Boston.
Yes, there can never be enough coverage of that, I guess. So thanks for having me back. It's been a wonderful time. And I guess I just wanted to pay homage, to the late Ted Stevens. Without him, we would have never had so much entertainment at his expense, with the internet being a series of tubes. And I hope that nobody would find it off color that when I learned about his death, I put up a post on Twitter. I put out a tweet wondering if the afterlife is a series of tubes. So here's to Ted Stevens.
We're out there scooting around the galaxy in wormholes, no doubt.
Yes.
Yes. Goodbye,
Merging
Senator
somewhere
Ted.
else.
Yes. All right. So go follow Evan. He's Internet Cases on Twitter, and internetcases.com is his excellent blog. Thank you so much for joining us again, Evan. And thank you, all of you, for coming on TWiL episode 73. We'll see you next week, Friday at 11 o'clock. Take care, all.